All right, thank you everyone. I'm really excited to be here at this point to share with you this research I've been doing for a long time. The dissertation is called What Role Does Custom Have in Sharia? Looking at Muḥammad Amīn Ibn ʿābidīn, continuity and the sacred balance in the Ḥanafī legal tradition, which I will explain. Okay, a brief outline, what I'm going to cover in the next half an hour. Introduction with a little biography to Ibn ʿābidīn and his life and why I think he's important. The research problem, which is looking at differing notions of Sharia and some of the assumptions that analysts bring when they look at a concept like divine law or Sharia. Key concepts that are going to help me and us guide us through the research today: the concept of divine law and where do we get those definitions from, and Sharia. And then after explaining my research, I'm going to try to reframe Sharia and try to approach it in a different way. And to do that, I come up with this category called the sacred balance, which I will go through is this calibration of different realms, which I'll explain. And then lastly, the contributions to Islamic studies specifically, and then religious studies in the academy more broadly. Introduction. All right. So when I arrived in Damascus about 2008, before I learned Arabic, everyone was talking about, you got to buy Ibn ʿābidīn's work, this 20-volume work, massive work, right? And so I purchased it and I put it at the top of my shelf. I'm like, one day I'm going to get to this thing, because people were still bragging about this guy. They're saying, oh, this guy studied with the son of this guy, and the son who studied with Ibn ʿābidīn. And this guy read all of Ibn ʿābidīn's works. And so I knew this guy was important in Damascus, but also in India and Egypt and Anatolia, Turkey. He was really important. But when I came back to the West here, I looked for research articles. There was only 3 articles that I found, and they weren't even that good. Well, no, they were good, sorry. But the thing is, I saw that they had a very different understanding of Ibn ʿābidīn than what I had experienced overseas. And so that led me to research this person. So his name is Ibn ʿābidīn. He dies in 1836. And he's part of this tradition, Ḥanafī legal tradition, that started 1,000 years before him. But nevertheless, it still continued until his time. And I thought that was really interesting, because this person is writing in the form of, the classical mold, which is a commentary upon a commentary upon a commentary. He's still writing in that model, and he's trained as a mufti, in which he studied all those classical books that were studied for the last 500 years, and then he started writing commentaries upon them. He started teaching them, and so he's constructed in this way that we think the pre-moderns are constructed. But when I started looking at the work, he's dealing with an issue called securata, security, which is the Arabicized word for Italian security, insurance, which is linked to capitalism and joint stock corporations. So I was like, wow, this guy has one foot in our world and one foot in that other world that's gone. Anyway, so he is a prolific writer, and I thought there were some interesting things about him. Particularly, there's a lot of claims made about what Islamic law is supposed to look like in modernity, but if the academy, we don't really know what preceded in the 18th and 19th century, how do we make claims whether there's discontinuity or continuity? And I noticed all the claims are being made like comparing whatever Islamic law looks like in modernity to some classical golden era that existed back in the day, whereas Ibn ʿābidīn is right there at the cusp. And an important thing to know before I tell you about him is, in the 1500s, the Ottomans, 1513, the Ottomans take Egypt. 1513, they take Egypt first, right? Yeah. And then what they do is they make, and Damascus, and then they make Hanafism the law of the land, to centralize it. So they create these institutions in Istanbul, 12 colleges that you have to go to, and they only allow muftis. Muftis are people who give legal opinions. A judge is a judge who gives a legal ruling. And if you want to be one, you have to go to one of these imperial colleges, and then they'll place you out, farm you out to all the different areas. And so Hanafism becomes bureaucratized, right? And it becomes part of the institution. And so Ibn ʿābidīn is born into that. He never leaves Damascus. Nevertheless, people from all over the Muslim world want to study with him. He gets this reputation that I think is interesting. So in order to get a job as the working mufti, you have to have connections or have graduated from one of those institutions. He doesn't do that, but the person who comes and becomes the mufti of Damascus realizes, well, this guy is different. He is special and he knows this stuff. And so he takes Ibn ʿābidīn, makes him his assistant. And so Ibn ʿābidīn basically runs the mufti office of Damascus. And from that, he gets questions from all over the Muslim world, even from India, but especially greater Syria, Anatolia. And so not just legal questions, there's theological questions, everything you can get. I mean, thousands and thousands of questions. And I think that throughout his practice of writing fatwas, you see his ideas changing about the function, how Islamic law should work, and how the Sharia adapts, and ideas of continuity, and I was able to look at those. Okay, so Ibn ʿābidīn, Hanafism. He's from this tradition called Hanafism. Now the reason that's interesting is it starts in Iraq with the eponym Abu Hanifa, but then it spreads to Central Asia, even goes all the way to China, to India. In Morocco we have Hanafis, in Africa, and as it moves into these geographical locations, it comes up with new concepts, new authorities, new texts, new ideas of how to move the tradition forward. And the tradition has a lot of resources that Ibn ʿābidīn is going to access in order to move the ship forward. Because here at his period, there's people are looking at the Ottomans and they're kind of imploding, as I'll show you in a second. So some people think we got to get rid of Hanafism because the Ottomans linked up with Hanafism. Hanafism is part of the problem. So this is where we have Shawkani is with him, and other people who think that the way to move forward is to get rid of this 1,000-year tradition and start new. Go to the sola scriptura. We need to go back to the original text. So Ibn ʿābidīn has a different model of trying to save the ship, and I think it's interesting that some of the ideas to look at these two models. Okay, so. Okay, Ibn ʿābidīn's life. This is in his lifetime. Muhammad Ali declares independent Egypt. Muhammad ibn Abdul Wahhab, the Wahhabi movement, take Mecca in 1803. 1805, they take Medina, right? And Greece in 1821 becomes independent, nation state. So we have a shift from agrarian to industrialized economy, right? Because most of the 1,000 years of our texts, from Abu Hanifa, going back to the beginning, it was an agrarian economy with very small manufacturing. However, in Ibn ʿābidīn's life, it shifts almost overnight, and you have this influx of goods coming in from the West, and they're siphoning out all the material and wealth out of the Middle East. And so, also Russia takes the Crimea, and so you have a lot of internal and external chaos. And you have the Ottomans and their ability to project that they are the religious caretakers because they lost Mecca and Medina, right? They're losing their religious stripes as well, okay? So they're losing geographical land and their authority. And Ibn ʿābidīn is going to try, his allegiance is not to the Ottomans. His allegiance is to what he calls the Ummah, which is the Muslim community. It just happens that they're under the protection of the Ottomans at that time. Okay, and this is why Ibn ʿābidīn writes an important essay, as I'll come to, which is on custom, and he is the first Hanafi to write an independent tract on custom, because before that it was spread out in other books like legal theory and legal maxims. And in the century before, in 1685, we have a Maliki writing the Amal of Ahl al-Faz, it took 1,000 years to get the first independent tracts on custom, essays on custom, which I thought was interesting. Like, what's going on that they didn't have to write an independent essay? And I think it's because of the shift from agrarian to industrialization. You see all the business transactions are changing, and then the shift from empire to nation state. Okay, so the research problem. I'm going to look at different ideas of what Sharia means. Okay, so I'm being reductionist here. I'm lumping everyone together. There are groups, there's pre-Edward Said and then revisionists afterwards, but nevertheless, this is the dominant narrative here in Islamic legal studies, that whenever, there's people outside. Should we open the door? They're just sticking their head in. It's just like, I feel awkward. Yeah, a little bit. Okay, so the dominant narrative is that in the beginning, there was this golden age because everyone is using their own reason and they're not following other people and they're writing original works. And therefore, they're using their reason and it's great. And there's a very, the scholars of this who are analyzing this era, what is Islamic legal studies? That is the academic Western study of Islam as we know it, that we're part of. And the narrative is that the first few hundred years was great because no one was following each other and everyone was independent. However, after the birth of these legal traditions and theological traditions, people started writing commentaries. Commentaries are derivative, right? And they're just continuing ideas and defending ideas that were already laid down. And some of the problems of why the decline happened is because Islamic law was limited in jurisprudence to 4 sources: the Quran, the Hadith, which are the material sources, and then consensus of all the scholars, and then analogy upon these 2. And there was systematic derivation. What I mean by that, there's hermeneutical rules laid out in usul al-fiqh, in legal theory, and these rules are to preclude any outside influence. It's almost like a machine that you pop in the Quranic ayah or the hadith and it pops it out automatically without any human influence. And so because of this rigid method of derivation, the Islamic legal studies holds that there's a rupture between theory and practice. As society kept advancing and the Muslim scholars, the Sharia scholars, were left with this rigid way of interpreting the law, the books had certain opinions while society kept going, and there was a rupture basically, and people didn't really care what the books had because they were so they weren't relevant for the time. So that's how the picture is until 1798 is when Napoleon shows up. When Napoleon shows up in Alexandria, he brings with him the ideas of the French Enlightenment, French Revolution, and lo and behold, Sharia becomes flexible. It's based off principles, not off scripture anymore. It's based off objectives of facility and ease and livelihood. And they start using customary practices and social influences. This is what I'm going to be talking about this. Customary practices would be not a custom that pervades the entire community, ummah, because they would subsume that into consensus. This is like local economic practices or local practices within a locality, and you have the opinion in the archive of Hanafism that you receive, and it goes against the local custom. What do you do here? So custom started having a more prominent role in the contemporary era, and it started catering to humanistic considerations. This is someone else's word. But nevertheless, you see there's a very big difference of how Islamic law post-Napoleon and pre-Napoleon, okay? I had the same idea, okay? So just really quickly, this is Ibn ʿābidīn's text on custom. After he lays out all his arguments for custom, this is a footnote, right? This line here, I thought, this was printed in 1908, so I just thought this was a modern editor adding this in. So he goes, these are great arguments for custom. We have to use, because the Sharia is based off ease, and this is one of the goals to make the Sharia easy in facilitating people's lives. And the Prophet Muhammad was only given 2 options, except that he chose the easier of 2. And I was like, man, what is this soft, easy, modern liberal ruining Ibn ʿābidīn's pristine classical text? You see that because if you're a real scholar, you'd be quoting precedent and going back to the sources and not just doing this cheap gimmick. But then I realized, oh wait, this is Ibn ʿābidīn himself. And then the ease thing, oh wait, he's quoting Khayr ad-Din al-Ramli in Fatawa al-Khayriyya in the 1600s, the Allama al-Philistine. in Palestine is a scholar, he's quoting him from the 1600s, and then he's quoting Sarakhsi. So it goes all the way back to istihsan, which are these tools that Hanafis have. So again, I thought, I had this idea that these moves were rupture, okay? And then this other part, he goes, I know that my arguments are strained here, and that they're not so intuitive, but I have to do this because we're causing, everyone is subject to this problem, and I have to create an outlet for them. He's working backwards, okay? He's not like popping in the Quranic verse or the Hadith and just cranking it out without any concern for its implications on society. He actually, implicitly admits that he has this problem, and he's going into the tradition to trying to find a problem, trying to find a solution. And so again, these are two things that I thought were, Ibn ʿābidīn, he's authentic. He would never stoop to this low, But again, so that was in the beginning of my research. So then I realized, wait a minute. Ibn ʿābidīn himself, to ground custom, he quotes the Quran, and then not only does he just quote it, he quotes and he goes all the way back to the earliest Hanafis. Even Shāfiʿī, Abu Muzaffar Sam'ani says that Shāfiʿī also held this verse, وَأْمُرْ بِالْعُرْفِ. The Prophet Muhammad is commanded to treat people according to their customs, or what's good known according to them. This other hadith, what Muslims deem good is good with God. So Ibn ʿābidīn quotes these hadith, and he shows just lists of people who also have done that before. And again, these God wants ease for you, not hardship, and the Prophet would choose the easier of two options. So again, I was learning from him that, wow, these are not just cheap tools. These are actually not only are they in the Quran and Hadith, but scholars from the beginning, from Shafi'i himself, had been using these verses to adjudicate different customary practices and facilitate things. Okay, so key concepts. Now, so you see my own shift in thinking. In order to help understand what was going on here, I started thinking about what does it mean to have a divine law? When people think of divine, what assumptions do they have particularly in post-enlightenment? What does the divine mean here? Noel Coulson, he writes an introduction to Islamic law, okay? And he explicitly says, divine law is an inflexible, unchanging system with absolute norms of eternal validity. And he says it has to be imposed top-down, like in an authoritarian way, and there's no influence for society. And Professor Halab, when he's analyzing Ibn ʿābidīn in his article on the essay on custom, he knows that Ibn ʿābidīn is trying to argue that custom has a role in the Hanafi school, right? So he's pulling from Hanafi precedent. So he thinks he's a schizophrenic, epistemological schizophrenic, because he's torn between the archive, that what's been handed down to him in the 1,000 years of Hanafism, and the humanistic considerations, because the Ottomans are trying to reform their economy and their military, and Ibn ʿābidīn is under the influence of the new zeitgeist of the early 1800s. So Christine Hayes helped me conceptually here, because she told us that in the West we've inherited two competing notions of what divine law is. The first one is of the Greeks. The Hellenistic notion is that divine law is top down, and it is authoritarian, it's rigid, and it can't change, right? Because it's from the unmoved mover, the unchanging changer. So it is permanent and unchanging and grounded in capital R, ontological reason. It has all these assumptions with it, right? Whereas she says the rabbis have a totally different notion of divine law. For them, the divinity of the law is in the fact that it's flexible, it's based off mercy, reconciliation, and it's adaptable to wherever the Jews find themselves in the diaspora. They're moving around, and they're able to have what some people would think are like so. The Hellenistic view would see the Jews and they would make fun of them. She shows this actually, how you can't play with divine law. It has to be adopted top down. And so I think at the end of her book, she says that I bet this is happening in Islamic studies, in which people are bringing in the other notion of a divine law, like a Hellenistic one, and imposing on the Sharia. Because she's saying in Jewish studies it's happening where they're obstructing and they're coming up with conclusions that are not coming from the text because they're imposing an idea of what they think divine law should be. And she's at the end, she's just like, I bet this is happening in Islamic thought. Someone should check this out. There's my dissertation. And so I wanted to see, it's not something they're consciously doing. It's just, where did he get this definition from? Like, no, it's not in Islamic sources. And so, and with halak, you see the divine versus humanistic considerations. There is a little bit, if you're following the Sharia, there's no room for humanistic considerations, according to the scholars who have looked at Ibn ʿābidīn. Okay, so when I'm going to try to reframe an understanding of Sharia and divine law, but this is what I call the sacred balance. Sacred in that Ibn ʿābidīn thinks it's a duty upon every jurist to consider the consequences of their opinion. So the sacred are ibadat in the sense of Durkheim. These things are cut off from the profane, like prayer and fasting, regardless of the political situation or economic situation. You have to maintain the 5 prayers, and that's why there's a solid line. Whereas the socioeconomic, here the rights of God are established. Here are the rights of humans, okay? And the Sharia doesn't exist in a vacuum, it exists in a particular location, and the jurist has to assess the effect of his opinions economically, even politically and socially, upon the people that he's giving the fatwa to. Otherwise, he'll end up causing more harm than any good he's doing. And so this is a term I come up with for Sharia, intercontextuality. It doesn't exist in the vacuum, it's a Platonic world. It exists in a particular location, and therefore there's going to be particular influences, socio-economic and politically, that the jurist has to be aware of. The sources in each circle are different. The political, here, Ibn ʿābidīn and all the Hanafis say there's no room for reason here, because how do we know how to worship God? He's in the metaphysical, we can't reason to that metaphysical world, and so they have to depend upon revelation. And so that's why the sacred, there's no room for social influences and reasoning how to worship God. You got to just take that from a source, the Quran. But here, you're allowed to, because the goal is to, like I said, haqqun nas, fulfill people's rights, and reasoning and customs have a large influence. When you get to here, he said explicitly, he's quoting Ibn Nujaym 300 years before him, there's no text guiding this realm. It's based off general principles and what serves the good of the ummah. So as you move out further from the circle, you see there's more like, flexibility? No, let's see, that's kind of a loaded word. Let's see, there's more room for the influence of non-scriptural sources. Okay, and what I see here, because Ibn ʿābidīn is born into the Ottoman Hanafism, which Hanafism is already bureaucratized, there's already this division of labor. It's interesting, like he'll go pages like talking about bad economic policies, but he won't, I mean, in retrospect, we know they're bad. And, I'm talking about debasement. If you keep debasing the currency, inflation goes up, right? And so he's talking about how to reconcile this, but he never criticizes the Ottomans per se. And so there's this division of labor that is latent there, in that the Ottomans and the Ottoman economists and the Ottoman politicians, they will lay out some things of what to do, and then the Hanafis, the Sharia scholars, are supposed to try to find a way to find validation within the Hanafi system for that. However, the differentiation of realms here goes back to Muḥammad al-Shāṭibī, who is 1,000 years ago, and it's not a move to secularization. The recognition that there are limits to what the Sharia scholars can say, and that the political is almost like out of their hand, is not a move to secularization. It's just a way that the Sharia tradition works, not in a vacuum, but always in a particular location. And secularization, what was I going to say? Exactly. Okay. Now I'm going to just go into some of these really quickly. The different realms of the Sharia here. The first one is ibadat, or worship, like the 5 prayers, but also Ibn ʿābidīn includes Quran, reciting the Quran. What happened was there was a plague in 1826. A bunch of people died in Damascus, and the families of the deceased wanted to honor their loved ones, and so what they would do was pay a Quran reciter to recite the Quran for them, and then donate the rewards to, sorry, who's that?
Gardener.
Oh, okay. Donate the rewards to the dead. And so he says that storefronts popped up in which you could just walk up and purchase a recitation of the Quran. And he just thought, like, you know, if it hadn't been for the money, the person would not have been motivated to read for that deceased person. And it became a cultural norm in that if you had someone die, you would go pay for Quran recitations for them. Okay, so the Hanafis of his era were actually validating this because, hey, we're Hanafis, we believe that custom has a role. This is custom in Damascus, and let's roll with it. This should be valid. And so for Ibn ʿābidīn, though, he doesn't think that custom or socioeconomic influences should enter into the realm of worship, and because he thinks the Quran is to like be pondered. The purpose of this realm is to discipline the soul. So he's borrowing ideas from Sufism, in which there's this part, Sufism, Shariah is like the outward practice, but there's an inward fruit, which is that, you know, you're supposed to have these virtues and witnessing God. All that is not happening if you're paying someone else to do the work for you. And so here he's very anti-custom in this essay. It's almost like a different person, because it is actually. This is written before he became a mufti, and then he worked for 13 years, and then he wrote this one, the next one, which the case study is. The reason he writes the custom letter, the essay on custom, is because it's debasement policy. So what happened was, like, there is a hadith from the Prophet that the Prophet Muhammad said that if you sell gold and silver, you have to weigh it. Okay, you shouldn't just sell it haphazardly. And so in Ibn ʿābidīn's time, the coins had gold and silver. Now the Ottomans need money for military reforms. So they start taking the gold and silver out of the coins, and what's left with, there's a bunch of coins being traded at face value. However, the gold and the silver within it is there's discrepancy, and according to the inherited Hanafi doctrine, you can't do that. You have to ascertain how much gold does each have, and you have to before the sale. And so Ibn ʿābidīn writes the custom essay just to that's what motivated him to write the essay on custom. And he comes up with so custom has a role here, custom doesn't have a role here. Lastly, now, again, he's saying there's not many explicit texts that could guide us through here. And so the caliphate was gone, according to Hanafis, that after, in 1258, we have the Mongols come, and they kill the last Abbasid caliph. And this is what the Hanafis say themselves. They're saying that, okay, after that, there's sultanate. Sultanate is what you call a ruler. Like the Ottomans were not caliphs, they were sultans. Because they lacked the one thing, they were not from the tribe of Quraysh. The classical doctrine, if you wanted to be the legitimate caliph, you had to be a descendant from the Quraysh. The Ottomans are Turkic people, they're not caliphs, and therefore from about 1500, the Hanafis in their books are saying this caliphate thing is over. And then in 1774, right before Ibn ʿābidīn is born, the Ottomans use the term again because they're losing all these lands and they want to extend their influence into Russian lands. And so they come up, they revive the caliphate again. And Ibn ʿābidīn thinks, you know what, this is a good pragmatic tool to call the Ottoman Sultan the caliphate, because the Sultan only has influence within his lands. The caliphate has influence even outside. And so if the Ottomans become the caliphs, right, then Muhammad Ali, Muhammad ibn al-Wahhab, all those Muslims who were rebelling, then become legitimate targets to fight against. And so he wants to centralize power back and consolidate power back with the Ottomans. He doesn't say the Ottomans per se, but at the same time, he recognizes that the state and any form of governance is always beholden to the Ummah, and he therefore lays out all the different ways in which the Sultan or the Caliph can be deposed. If he's not meeting, he says the pathways, if there's not public security, if the marketplace isn't functioning well, you can even I thought he would say if people aren't allowed to pray or something, but he says even at the most mundane things, if there's widespread economic chaos, then the caliph's not doing what he should be doing, and therefore, if it's feasible and it doesn't lead to harm, you can use rebellion to kick him out. So you have this limited caliph in which he has to, but he's very cautious, And so these are the aspects of the three realms. And now I want to reframe the Sharia. It's a discursive tradition. And what do I mean by that? It's a discourse happening in certain times and places, and it's ongoing, right? And so it can have rapid changes, but they're still continuous in that they're drawing from the previous texts and ideas. And it's a porous category. So what do I mean by porous here? So Ibn ʿābidīn here, for his doctrine of why it's permissible to rebel against the caliph, he's pulling from Sayyid al-Sharif or Jurjani, which is like a philosophical book. Taftazani, he's pulling from these books. From Sufism, he's pulling from in terms of explaining the function of worship on the soul. Mathematics, he's bringing stuff in there for inheritance. Astronomy, he's doing something with sighting the moon. So the Sharia is in conversation with all these other realms, and this is the intertextual realm, and therefore it's clearly a porous category that's being adjudicated by the Hanafis over time to decide what concepts, phenomena, ideas need to be brought in. Case in point, Siyasa Sharia, the hybrid. Okay, before Ibn Taymiyyah, Ibn Qayyim, it could have gone different ways. There were some scholars who thought they didn't go together, but Ibn Qayyim argued at length that this hybrid, particularly in the vacuum after the Mongols and the Abbasid collapse, that this was needed, that Sharia needed to be brought in to siyasa and have this hybrid in order for the fluidity of to help the ummah move forward. And so the same thing with Sufism. So clearly over the centuries, this is being adjudicated. And I think that, this helps us. I'm not trying to define Islam, but when we're looking at Islam as an analytical object and we try to understand what are the constitutive parts and how they relate, I think the porosity of the discursive traditions will help us at least understand how these things relate and change over time. Okay, and lastly, this is Ibn ʿābidīn. This is weird. So everyone, I'm arguing he's not so special, basically. They're using, the people who do talk about him say he's revolutionary. They use words that signal rupture, that he's doing something different. I am saying he's not. It's just that you didn't look to the previous generation before to see what was happening. They compared him with some Platonic idea of Sharia that they had in their head. And if we're going to look back as historians and try to see what was the notion of Sharia that from Indonesia to Africa, right, maps on to the Balkans to Bengal complex, it has to be porous because of looking so different in all these different areas. And again, so like these binaries that we know, tradition versus modernity or divine and humanistic, there's a fluidity to these religious traditions that they can adapt and transcend some of these boundaries. And I think that for religious studies, after the Enlightenment, we privatized religion. And so when we look at other traditions, Islam, Buddhism, I think these traditions have something to contribute to these other areas like philosophy, politics, economics. However, if we have the idea that Sharia or Islam is just a billiard ball or a silo, it's not, and it doesn't have anything to say outside of that discipline, then we're not benefiting from those traditions and those insights that they have in these other realms. And I think that first understanding you know, the porosity of the category will help us get there. Alrighty. Thank you for your time.
All right, thank you very much.